Back down, then came that rumble way down in the ground, and the smoke and gas belched out of that mine. Everybody knew it was the end of the line for Big John. Big John, Big John, Big Bad John, Big John. Now they never reopened that worthless pit, they just placed a marble stand in front of it. These few words are written on that stand. At the bottom of this mine lies one hell of a man, Big John. Big John, Big John, Big Bad John, Big John, Big John, Big Bad John.
Welcome to the WINGIT call. August 29th, 2016. Today is a trust call with Richard. Richard? Well, I got to say this. There's a few things that need to be addressed because we have a few naysayers out there. So, Richard, take it away.
Thanks, Jerry. I guess we knew one of the things I like to do on every call is when things get a little weird with what might the information that might be going on, I like to spend a little bit of time making our members, especially the people who've taken the plunge to go ahead and do the first part of their trust, make them comfortable with their decision. And I think this is a particularly good day to do that again, and I want to do it in two different ways and cover two different subjects. But the first thing I want to do is just make sure that everybody understands that the trust that you guys have contracted with us for is written and is owned by an extraordinarily reputable law firm called Rosen & Rosen out of Houston, Texas. And I remember back in 2011 when I was first doing my due diligence and found Rosen, I did what everybody should do if you have concerns, and that I had a friend of mine call up the Texas Bar Association and do a check for the Rosen Law Firm with the Texas Bar. And what I found made me feel very comfortable because they had never, ever had a complaint issued against them in the state of Texas, or any place else for that matter. They are licensed to practice law in the states of New York and Texas. And back at that time, in about 34 years of being in business, 33 years of being in business, they had never had a complaint issued against them. And to this day, I still think that that's the case. So from that standpoint, one of the things I was reading something about vetting, being responsible for your own vetting of your information. Rather than just take someone's word for it, go and do your own due diligence. And there's several ways that you can do that if you need to have some comfort in this. So one of the things you can do is have an attorney friend dig into the Texas Bar website and find out about Rosen. You can also call the Better Business Bureau. There's plenty of ways that you can vet the legitimacy of an organization. Plenty of ways. And you also, when doing that, you've got to think of it's hard for any organization to go 37 years without somebody being unhappy. Somebody is just, but there's never been a complaint that we can find filed against the Rosen & Rosen law firm. Paul Rosen and his son and daughter are the principals in that company. There are other attorneys involved, and they have been doing business in an extraordinarily reputable way for now 37 years. The other thing you have to do in doing your own due diligence is use some common sense. Over the course of the last 37 years, and even before that, because one of the principals is still involved that was involved before Rosen got involved with the trust. And you'd think that after all these years, if what we were representing, and me representing, and what the law firm represents, you'd think that somebody would have complained, and if this was not an extraordinarily legitimate operation with an extraordinarily legitimate trust, that there would be people lined up suing the law firm, and that is just not the case. And I know if the Texas bar is anything like the California bar, it is guilty until proven innocent, and they take no prisoners, and it is a tough process to go through if there's a complaint against you. And you'd think that somebody would have, or if it was, don't want to use the word that I heard recently about what this is, but you'd think that if there were that many problems with this, that somebody, that there would be clients over the hundreds of trusts that they have written, if not thousands. And they don't tell me how many trusts they've written, but hundreds and hundreds, if not thousands of trusts, that there would be people lined up to sue them, and with complaints and problems. But that's just not the case. So I just want to make everybody comfortable with the fact that this trust is not, it is an extraordinarily complex, I don't want to say complex, sophisticated trust, but it's so easy to manage. And what you've gotten here, what you have here is to me, one of the best things that the program that we worked out with, that we offered to the McGuire, to the WINGIT call, has been extraordinarily good and will continue to be for the people who've taken the chance on this. So I think that I want people to understand there's ways that you can go and do your own vetting, go and check it out, make yourself comfortable yourself. Don't take anybody's word. Don't even take my word for this. Go and do your own due diligence, vet it out, and there's plenty of ways that you can do that. Now, I want to move on.
Richard, I have two questions.
Yep.
And it's going to be redundant, but give me a little latitude here. First one, you are an authorized representative by Rosen & Rosen to do these trusts, to get them all set up, to send to Rosen to do the finalizing on them.
That was going to be the next thing I got into. But yes, I have the way that the law firm set it up is that there's a law firm which is owned by Paul. There is Masters Copyrights LLC, which is a wholly owned company owned by the Rosen law firm, and I have a contractual relationship with Masters Copyrights LLC, not necessarily to sell the trust, because the law firm sells the trust. When you contract with the law firm, when you contract for the trust, you're contracting with a law firm. The law firm sells the trust. I facilitate the trust, and I have the ability through my agreement with Masters Copyrights LLC to theoretically discuss anything that is on the website. I'm not supposed to, and I don't want to discuss complex tax issues or complex legal issues, but to the extent that it's published in the website, I can discuss it with clients and basically help them facilitate their trusts. I arrange for the documents. If someone wants to which I'll get into in a minute, about if someone wants to go ahead and get their full trust, I've helped them do that. And all the checks and all the contracts go to the law firm, and the law firm takes care of it. So, and I think that there was also a question of whether I need a license. There's no license. You have a contractual relationship with Masters Copyrights LLC, and I can discuss anything theoretically that's involved in the website and on the website, that it's basically public information, and I can do that. Basic trust thing. But go ahead, and before I get off on this, there is if you look under the history of the trust, there's a left-hand tab. First of all, my name is in the contacts part of the website also. And also there is in the history of the trust, which is a link on the left-hand side. You open it up and read down. In there it states that I am a licensed agent of the Masters Copyrights LLC. I'm sorry, Jerry.
Nope, you just no. That's I was going to say, where do you go to see that you're an authorized agent? That takes care of all of it. So while Richard addresses a few things, *2 to raise your hand, and then we'll take some questions here. All right, Richard.
Yeah, there's a couple other things I just want to talk about here just for a few minutes, and I'm going to come into. But as everyone knows, we don't have any idea when Jerry is going to let this RV go. He's been holding it up, but we're going to put the blame on him. He's got broad shoulders. But being serious now, we don't know when it's going to go. And so we are, as I remind you again, we are taking applications for additional trusts after the RV, and they're coming in first in and first out. We're taking the applications for it, and we don't have the exact trust applications up yet. We will soon. Just take a regular trust application that, by the way, on the new website, it is back under download. It's not hidden behind the key. There's the piggy bank. It's under the button of download application. It's there. So take it and write on it post-RV business trust, post-RV Masters Trust, post-RV charitable trust. And you'll go in line, and we will contact you after the fact, and you will be in line with the application. No deposits required, and don't date. This is the only time, and I want people to pay attention. Don't date the application for the post-RV trust. Now, I'm getting some trusts from people who are not clients, let's say, of Masters Trust yet. The trusts that we're doing now are for people who are part of the program that we have, which is the deposit, the application, the one that we're doing now. The ones that are new after that, I just want to point out, if you have sent one in, then we're going to do that only for asset protection, because it will be too late after that for people who want it for tax deferral. So with that in mind, if you've sent in, if you're not already a client of mine or of Rosa, and you're sending an application for afterwards, we'll wait a little while and then call you and process that order if you still want to do that. But it won't be in time to participate in any it won't be in time to have your currency assigned into the trust prior to the RV. Therefore, there won't be the tax deferral part of it won't be available. I also am getting some applications for people who haven't fulfilled their contractual relationship with the program too, and the fulfillment of the contractual part of this is the fulfillment of the deposit. If you are 30 days old in fulfilling that portion of this contract, which is the deposit, I would be a little bit concerned. We're going to call some people who have not fulfilled that portion and ask them what they want to do, but that's an important part of this thing. It's not for the money. It's not the issue. It's not the money. The issue is to be part of this thing, the deposit has to be completed. And I'll just leave that there. Let me look at okay. Now the last thing, before we get into anything else, is that the agreement that we had with everyone who's participated so far is that we will defer 90% of the cost of the trust until after the RV. And that's not going to change. You'll never be pressured about it. You'll never be called about it. This thing happens, then everybody knows what to do, hopefully. We can go over it again. But I also want to bring up the issue recently. A number of people have called up with situations that they went ahead and paid their 10%, deferred their 90%, but they called up with situations that they had that made it imperative, not imperative, that it made sense for them to go ahead and get their full trust because an event was going to happen that it made real sense to go ahead and do. And I'm going to give you some examples of that. A client called up recently and said, I have a interest in an investment property that's technically, I think it was a fairly small percentage, but it was going to be worth about $250,000. And it had gone through a couple of 1031 exchanges. So she said, what do I do? How can we take care of this? And I said, well, let's, if we go ahead and you'll need your full trust to do it. She said, fine. Then we go ahead and we take your share of that investment. We assign it into the trust, and which we've done. And now when that pays out, because it'll be paid to the trust, that person will probably save $100,000 to $125,000 in capital gains taxes. And so it made sense for that person to invest the other $4,500 to save $100,000 in taxes. So that full amount of the payment will come back into the trust as into the corpus of the trust, and that is tax deferred until, again, she creates a reason to make it a taxable event for her, or him, or her, it. Sorry. There are other reasons that people may consider this. If you're selling a home, there may be reasons to explore that. If you've got stock options that you have that you can exercise and that you probably will have to pay capital gains taxes on it, you might want to explore that and call up and run that by somebody, maybe even one of the attorneys if I can't answer it. Any kind of investment properties, doctors. What a great way to cut your liability. Doctors and chiropractors and anybody who has to concern themselves with being sued, whether they've done something wrong or not, because we're in a suit-heavy environment now, there may be a reason that you may want to get your trust so that you can utilize the trust. Now, again, we're not changing the deal. I'm just saying that several people recently have done that, had reasons to do that. So look at things that may be going on in your life. A guy recently called me and said he had assigned he had a dozen antique cars. They were in beautiful shape, and he was going to sell some of them. And he wanted to go ahead and he wanted to go ahead and do what was necessary so that if he sold them, that money coming into the trust would be tax deferred, just like it's meant to be. So if anyone has a situation that they want to talk about, just give me a call and we will get an answer if someone wants to. Otherwise, this is the last I'm going to say on it, okay? Because the deal is the deal and we're not changing it. And then the very last thing is that we've had a lot of response about, or a lot of questions about whether we're going to have an event probably in Dallas. I'm certain it's going to be the first one after the RV, and the answer is yes. However, we're contemplating a meeting even soon, even if we don't have an RV. But what we want to do is open it up for people who think that they want to know more about the charitable trust and the business trust. And the business trust, we may have a meeting soon. If there's enough interest in that for whether the RV happens or not, we all hope it will. We all are anticipating, but we just don't know because we've been through it so much into this whole thing before. But if there's enough interest and people want to learn more about how to utilize the business trust, the charitable trust, even outside of the RV, let me know the interest level, and we may have one. We'll just have to see. We'll just have to see if there's an interest in doing it. And excuse me just a minute. Just let me know if there is an interest, and we'll go from there. And that is about it, Jerry. If we want to do a Q&A for a while, we can.
Well, I'm going to read some questions here, and we're not going to really elaborate. I'm going to read this first question here, but I think I want to get to some callers. Here's the very first one. It says, I have a master's trust through you. I have a trust bank account with your help. My wife and I are happy with all of your help and assistance. I want to put 50% of the total amount into a separate trust. Hey, Richard, there's a lot of noise there.
I'm silent.
Hold on. No, okay. Here we go. No, that's you moving around.
Well, I shouldn't be, but that's all right. I'll be still.
Yeah, just mute yourself for just a second, please.
All right. Yep.
I want to put 50% of the total amount into a separate trust that my wife is the compliance overseer and I'm the beneficiary. Should this be set up now, or can I do this after the event? You can do that after the event. Reason being is because you're going to exchange everything into yours, and then you can endow it from one trust to another.
Correct.
Richard, do we need to deposit our different currencies in separate accounts within our trust at the exchange time? I can answer that. No. I know why you're asking, and I'm going to say this. It's because we've always heard we have to keep the dinar separate from everything else. It will be separate even though it's in the same account, and here's why. Because when you go to do your exchange, they're going to give you a deposit. You can say, I'd like a deposit receipt for each currency. And so you write on there, dinar or BND or whatever it is, and that gives you, it's separate, but you got your total in case there's a tax question. This one has been addressed, but we'll hit it again. Can I have a master's trust with other trusts inside of it, such as one for my real estate purchases, automobiles, and one for each of my children, or one to just buy things as I need to? The master's, you don't have to have a trust for this original master's trust. Yes, there's going to be 3 different trusts offered after post RV. One is a business trust, one's a real estate trust, and one's a charitable trust. But back to the original trust, you don't have to have separate trust for each different item. This one trust will protect everything that you have.
Let me just take a minute right there.
Sure.
For people who are considering the other trusts, let me just give you a couple of rules of thumb on whether you really need to consider this or not. I don't necessarily believe that the average person who just wants to give. See, this master's trust, you can donate to any recognized charity, 501c3 that you want to. You can just donate to it. The only time that you might want a charitable trust is if you're going to be utilizing the charitable trust to raise money and donations. And the charitable trust allows you to do that. The trustee the beneficiaries of that charitable trust are other 501c3s. And if you're going to be doing fundraisers or raising money or having people donate in, unless you're going to be doing that, you may not necessarily need a charitable trust. It's up to you. It's simply up to you. The business trust. The business trust is set up to actually run a business out of. That makes sense, doesn't it? But it's especially important where you have partners. And so if you're going to have partners or you're going to have multiple people involved in doing business, you want to have a business trust. And then just remember that the difference between a business trust, the basic is that each year you have to distribute the profits of the business trust, but you endow it down through the partners who would have regular basic master's trust. And that's a non-taxable event and allows you to get money out of the business trust into your individual trusts. So there may not be a reason that everybody wants a charitable trust or anyone needs a business trust, but we can certainly talk about it.
Okay, let's go to our first caller here. I think it's Wayne, Michigan. Let's see here. Wayne, is that area code 734? Or is it Minnesota?
No, it's Michigan. It's
okay.
Michigan.
I haven't lost my brain yet. Thank you. Come on down.
Yeah, Jerry, thanks for the call. And Richard, I have a master's trust, and what I'm trying to do is I was going to do a post-RV for 2 additional trusts, one for my son, one for my daughter. I'm going to put money into that, and then when I die, endow those 2 trusts rather than the names with what's left of my trust. The question is, when I'm filling out the application, I made myself a trustee. Me and my wife need to be trustees, and then if we both die, then my son and my daughter, in each of their trusts, becomes the owner of the trust. How do I do that?
Yeah, well, what you would do is, if you want to, is that, yes, that's true. You can be the compliance overseer, the trustee of the new trusts.
Uh-huh.
You can make the kids the beneficiaries, and then the kids would be the successor trustee, successor compliance overseer.
Okay, so I would be I wanted it to happen so when me and my wife die, they get the whole thing. So
okay, then what you would do is that you would have to make one of the kids the trustee as a successor to the successor trustee of your wife, so or to the last person, either you or your wife, with instructions to liquidate your trust and endow in whatever percentage you want to from that trust to the two individual kids' trusts, and that would basically net your trust out, and that would not be a taxable event.
Right, but what I'm saying is I want to set up a trust for them right now.
Okay, then make yourself the
okay, but I don't know if I should be the trustee, my wife trustee, compliant officer, and then the kid or the child, each child should have his own trustee and compliance trustee, successor trustee and successor compliant officer. Would that work?
Yeah, how old are these kids?
31 and 23.
Okay, then one of the ways there's so many ways you could do it, is go ahead and let one of the two of you be the compliance overseer in the new trust.
Okay.
Go ahead and let them be the trustee of their own trust. And when you've got a good handle on the fact that they're handling things the right way, then you can resign as the compliance overseer and let them take over as the compliance overseer. But if you want to, that's one way.
Okay.
Or your wife could be the trustee and you be the compliance overseer, and then you both resign whenever you want to, but the kids would be the successor trustee.
Okay.
There's plenty of ways to do it.
So let's say my wife was the trustee and I was the compliant overseer. If she dies first, do I become the trustee?
Yes.
Okay, that's all I needed to know. And then on my trust, I'm just going to state the names of their trust in there, so there's no taxable event.
You would make their trust, when you execute it, you would make their trust beneficiaries of your trust.
Yep.
Endow into their trusts, and then you can take it out or leave it in. That
sure.
doesn't matter.
Okay. Another question I have for you.
Oh, okay. I'm sorry. Go ahead.
Real quick. I got a friend that wants. Are you still doing the $500 deposits for a trust?
Yeah, that's the WINGIT. That's the offer to the WINGIT group. Yes.
Okay, and they just fill out the regular application and then email it to you, correct?
But they send it. They send it to the RTH 6996 email. Yes.
Right.
And don't anticipate that. I'll give them instructions when I get them complete. I'll give them instructions, just
sure.
like I gave you guys about where to send the money and where to send it to. Yeah, that's fine.
Okay, that's why he wanted to get it. He's going to have the money in a day or so. So, all right.
Tell him not to wait. Tell him to get it. It's going to take a couple of days anyway. So tell him to get the application here, and then it'll be fine.
Okay. And it's just the regular application you guys have, or you don't have that secret place anymore, do you?
No, it's not.
Okay.
It's not secret anymore. It's on the download app. Yep. Okay.
I'll let them know.
All right.
Thank you, sir.
Thanks a lot. Thanks.
Toronto, web call. Come on down. Hello, web call in Toronto. Magic Gal, hold on. I got it. Magic Gal, come on down. Toronto.
Magical, am I on?
Yes,
okay,
we can hear you.
Okay, great. And so thanks so much for this. I haven't been able to listen to the other trust calls, so I don't have a lot of background on what's going on. But I'm in Canada, so my first question is, are trusts valid in Canada?
Hold on. If you want to listen to some more of the trust calls, If you'll go to my website, it's called thewingitcall.com, and in there you'll find a tab for the replay links for the trust calls.
Yeah, I know where they are. I've looked for them. I just didn't know if it was applicable to me because I'm in Canada. So are they valid in Canada?
Yeah, absolutely. This trust can be domiciled in any country in the world.
Oh, okay. Well, that's great to know. That was always my thought.
Well, but the only difference is that whereas our clients here get an EIN number, and it's through a portal on the IRS website, you would have to get your own SIN number in Canada.
Right, we all have those.
Well, you would have to get one for a trust. You'd have to.
Oh, it's a separate number?
Yeah, it has to be one that identifies the trust and not you. I
see. Okay. Because here all I've heard of, or all I've been able to find out is that it's only lawyers that set up trusts here, from what I've found. So I didn't know where to go aside from a lawyer, and I hear not to go to a lawyer.
Well, keep in mind that the law hasn't changed here. That a lawyer is legitimately the only way a trust can be sold. So it hasn't changed here. It's the same way here. And ours is sold through the Rosen and Rosen law firm. But what I would do is call up your bank. We can take care of the trust, and there's probably 8 clients in Canada that have trust from us.
Okay.
And just ask the bank, say, technically you wouldn't have to, you've got to do banking, and you have to have the equivalent of the EIN number. So just call up your bank and say, if I have a trust, what SIN number? How do I go about getting an SIN number or a number that will satisfy you so that I can do banking with a trust?
Okay, thank you. And so if I put a deposit down for a trust, that does not allow me to have my currency in the trust until it's fully paid for. Is that right?
No, ma'am, that's not right. What we do is that we will. This was a program that was approved by the law firm that they provide the documents and to do this, and so we can for the deposit to complete the agreement with the deposit is that we provide you with basically 3 different things. We provide you with it's called a letter of introduction, which is your banking resolution, so that you can legally go and open up a trust bank account. We provide a document that appoints you as the initial trustee of the trust. And then the third thing is a consignment form that you actually will fill out and list your currency and assign it into the trust. On the sheet, there's a place for 2 signatures. Both of them are yours. The top one is where you're assigning it to the trust. And the second signature, you're accepting it into the trust as the trustee. And now it's in the trust. It's an asset of the trust, so that when it increases in value, it complies with Title 26 of the IRS code, and it's tax deferred.
Okay. Now, are these non-statutory, non-irrevocable trusts?
The Master's Trust is neither statutory nor non-statutory.
Okay.
A non-statutory trust is a common law trust, which I don't think anybody wants to get involved with. You just ask Mr. Wesley Snipes how it worked out for him. So it's common law trust. The it's not true that the opposite of a statutory trust is a non-statutory trust. So
Okay.
This is neither. This is a irrevocable, complex, non-grantor, discretionary trust with spendthrift provisions. And all of those words working together gives it the asset protection and the tax deferral that we say that it does.
Okay, so then if I die and it goes to my beneficiary, they don't have to go through worrying about the taxes, right?
What happens is that
it
when
transferred to the beneficiary?
You would have a successor named, and one of your beneficiaries, and most of the time, one of your beneficiaries would be the successor trustee and the successor compliance overseer, so that when you pass, the successor automatically takes over the trust. It
Right.
becomes the trustee of the trust, and the trust just moves on.
Great.
It bypasses probate. You don't have to worry about that.
That's what I wanted to know.
Yep.
Okay, I think that's great. I'll let someone else on. I will listen to the other calls now that I know it's open to Canadians. Excellent. Thank you so much.
Yes, ma'am.
You know, I guess it'd help if I unmute myself. Nampa, Idaho. Come on down. Hello.
Hello, is
Nampa.
that me?
Yes.
Hello? Yeah.
Yes.
Actually, I live in Alaska, but I have a Nampa number. I just wanted to talk to Richard a second. We did get one of his trusts, and we really like what we're doing here with that. But I have a question. I didn't really quite clarify when we did this. When we change, we don't have to mention that we have currency when we go to the bank. But when we did the changing, with your settler, how do you actually prove that it was theirs before it became ours, and change that over? I was a little curious about how that works.
Let me restate. Let me clarify. You're trying to prove that it was the settlers before it was yours?
Well, I don't know. We had to sign something to state that it was that we received it from them.
No,
Okay.
That's not. Okay, the settler, because this is a non-grantor trust.
Okay.
The settler's position was created, and the settler's job is technically very short-lived.
Yes, I know that. Yeah.
Okay, so they came in, they sat down. Technically, what they're supposed to do is to hand you $10, because all contracts are about money or something like that. So technically, they're supposed to give you $10. And they signed the document, the same document that you signed, where the trustee and the settler signed. And that's the only involvement they have. They open up the trust. They basically fund the trust with $10 and other valuable consideration. And then they're out of the trust. From that point on, only you as the trustee can assign assets into the trust, or you as the trustee can accept assets coming into the trust.
Yeah, and that's what we did. Okay. I just didn't quite get that when we were talking about that before, Richard, so I just wanted to clarify it. I understand what you're saying now. Yeah.
Yeah.
Okay, not a problem.
Alrighty,
Well, thanks
ma'am.
for clarifying that. All right, thank you.
Thank you.
Bye-bye.
Yes, ma'am. Thank you.
It's like a free-for-all on the web calls. Lynn, come on down.
Thank you, Jerry. I have a question. I had lunch with a good friend of mine who's a tax attorney, and I've known her since the 80s. So I asked her, not mentioning the RV or anything, I said, do you do trust? And she said, yes, she does. And I said, well, do you know about a master trust? And she said, yes. And she said she doesn't do trust very much anymore. And she said this only for Tennessee, because I'm in Tennessee. She said a lot of people are going away from trust because in Tennessee, they're, I don't know how she said it exactly, creating laws or things are coming up where these trusts can be broken. So I wanted to get Richard's opinion on that comment.
Well, and I have, before you do that, and before he does that, if you go into the bank, because I've had a couple of people tell me that in Tennessee they've went in to what the heck is that? Oh. There we go. That is not me. Who is that? Oh, okay. All right. In Tennessee, I've had a couple of people. Just 1 minute, please. People in Tennessee, a couple of them have went in and tried to open up trusts, and the first thing the people at the bank are saying, well, you've got to register the trust with the state, and they have to know what's inside of it. And I'm saying, no, they don't. So you're going to run into that problem too. I just wanted to say that. Richard, go ahead.
Well, no state trumps the ability to, and even Tennessee. I mean, this trust complies with state, federal, and IRS code in all 50 states, and any wherever it's endowed. Domicile. But in Tennessee, it's no different. There's case law that the trust cannot, with rare exception, and I don't even know if Tennessee does this, but with rare exception, if you have set this trust up correctly, and because it's a spendthrift trust with spendthrift provisions, the trust is not penetrable, and there's case law to that effect, and Rosen won both of those lawsuits. And you can look in the website. So there are trusts that, yeah, they are alter egos for, the trusts that are the trust upon the trust upon the trust upon the trust. Those are basically alter egos, and the IRS looks at that and says, yeah, well, we can penetrate that. The ones where you put one asset into each one of them, but this trust is not, Tennessee law doesn't trump federal law in the ability to penetrate this trust. So it doesn't matter where it's domiciled, it still has the same power, and we've got a number of clients in Tennessee, and I'm not concerned about it because my sister's property that's endowed into my trust is in Tennessee, and I'm not the least bit concerned about it.
Okay, I appreciate it. We had another friend at lunch with us, so I did not go into detail with her what the trust was concerning and trying to explain how I knew about a master trust, because she did give me a strange look like, how do you even know what a master trust is? not in a bad way, just we've never discussed anything like that. But I was just wanting to bring up what she said, and get your opinion on it. So I appreciate it.
Well, let me make another statement too, and this is not. I meant to bring this up, okay, before, and this was back in the beginning. Is when you discuss something, don't rely on yourself to discuss it with a professional. Even I don't do that, and I maybe I know more than some people do, but I don't claim to know everything. For the law firm to expose an opinion letter in their website, and for Paul Rosen to do a video, that's what I would rely on. Let me say the first thing. If that's not true, and this goes back to the credibility at the beginning, if neither one of those things are true, that is a disbarable offense. The law firm can be disbarred. This is not play pretend. This is serious business. And so I meant to bring that up about the opinion letter. I talked to a couple of guys in the last couple of days that their attorneys, they've got trusts that are written by attorneys, and their attorneys won't give them an opinion letter. Now, who does that make sense to? You're not protected if there's not an opinion letter by the attorneys. So don't dismiss that as far as credibility. Anybody that's willing to put those two things out there. So my point was, when you're discussing it with, and here's this is a complicated thing. Show people the opinion letter. Show them the opinion letter, and let them debunk the opinion letter with a logical assessment of what the if they can figure it out. Now, I will tell you that there's a extraordinarily credible, professional, all women's law firm here where I live, and they do business with trusts, and they do a bang-up business with trusts, but all of their trust business is our revocable family-type trusts. And boys and girls, they charge a whole hell of a lot more for their trust than we do, and they do not offer asset protection, and they don't offer any tax deferral on anything that they do. And yet they had no clue about these types of trusts. And they're extraordinarily professional people, great reputation, wonderful women, and they don't have a clue about this. And the average accountant, tax attorney, unless they study trust law all the time, they're not going to know about this. So that's just take the opinion letter, hand it to them, and then go from there. That's what I would do.
And one other thing, a lot of people, when they go to talk to an attorney, they'll say, oh, yeah, I've got a spendthrift trust. And the attorney goes, oh, well, you don't have enough there. You must include everything else that goes with it, non-grantor, discretionary spendthrift trust. You have to have all that put together, memorized in your head, because if you just use spendthrift trust, they're going to think that you've just got a standard trust and they can do better. So let us go on to our next caller.
Let me say something to that just one more time, and I've said this many times. If you went into an attorney, and most any attorney, and you said, some idiot is telling me that if I have an irrevocable spendthrift trust, that I'm going to have tax deferral and I'm going to have asset protection in that, and the attorney probably would look at you and say, I don't think so, and that attorney would be right. Because a regular spendthrift trust is a special purpose trust. It's generally set up to take care of special needs kids that parents are getting older and they want to take care of them. So Jerry's exactly right. You've got to hand that opinion letter and describe everything about it, and otherwise they can't make the right decision. Sorry. That's it.
Colorado Springs, come on down. Howie on the web.
Oh, hey, Jerry. Hey, Richard.
Howie.
Quick clarification. Yeah, Howie, thank you. Quick clarification. Wouldn't you not say that when people refer to the trust as my trust, that is not the correct way to interpret this? That we do not own, we control, that in essence what we really are doing is we are representing the trust. Is that correct, Richard?
Yeah, I would think that's, yeah, because it's not, I mean, the average person is going to say my trust, and that, yeah, I guess that's right, but technically I think you're right. You're the trustee, you're the fiduciary on the trust. You're the trustee. It's not your trust. It's the trust would be more, I mean, the beneficiaries could probably say that, my trust, maybe easier than the trustee could, but that's right, Howie. I think you're right.
Okay. Yeah, I just wanted to make that clarification for people. I think that's pretty important, especially if you're talking to a bank. Also, the gentleman that you had introduced us to previously, Richard, I think in Houston, is that correct?
In Dallas.
In Dallas. Could you just clarify for us his position and his involvement?
He basically runs Masters Copyrights LLC.
So he works for Rosen & Rosen?
Yes.
Okay, I see. And my real question, my real focus right now is there any way we can get information? And I think the idea of meeting before the RV is great, but one thing that I know I'm interested in, and I'm assuming many other people are interested in, is that once this RV's, we're all going to probably be interested in buying property in some way, shape, or form. And I'm wondering how to advent that, and knowing that it's probably going to be 30 days until I get the main content of the trust. If there's any information that can be distributed, if Richard in Dallas, if there's anything that can be conveyed to us that would give us a clear-cut understanding of how the trust would purchase property directly, I think that'd be great. And I just thought I'd throw that out for comments.
Hey, Richard, what about that Dropbox link that I set up? Do you think that would help him?
It might. Yeah. I mean, but here's the thing. Basically, and I'll give you just a 30-second thumbnail, is that purchasing a piece of property is not going to change theoretically. I mean, you as the trustee, you as an individual can go and look at a piece of property. You're going to make an offer. Now, you can make this without the trust making an offer because you can act on behalf of the trust and not. So you go out and you make an offer. You write up an offer. You get it accepted. You do your due diligence period. You when they ask for proof of funds, then you go to the bank and you get proof of funds that your trust that you can do what it says it's going to do. That you got the money there. You go back and they're ready to close, and they say wire the money, and you wire the money. And a couple of days before you get ready to close, they will have you fill out forms that is your vesting forms. And you fill it out, and at that point, you just say, I want this to be vested in my trust. I'm the trustee. Here's my address. Here's my EIN number. Bada bing, bada bang.
So meaning that the property's purchased in the name of the trust. Is that accurate?
That's correct. It would be, they would record that their recording would be in the name of the trust. Now, if it's and that's easy. A car is easy to do when you do that. If you buy a new car, you just have it recorded. It would be titled in the name of your trust. I just got my renewal, my car license renewal, and it was sent to my trust name, my trust.
Okay, but do I understand correctly that we cannot mortgage property in the name of the trust? Is that accurate?
I think it's more that most banks are not going to give a trust a mortgage. Now, I mean, I read someplace, and I not read or talked to somebody where a bank was considering giving a trust a mortgage, but most banks won't do it. They won't give a trust a mortgage because it's especially this type of trust because it's very complicated and it would change things if they had to foreclose. So I think they're going to they would put it into the name. If you're going after a mortgage, you're going to have to take the mortgage out probably in your name. And then a day later, just after you close, just do a quick claim deed and put the title into the trust. But if you're paying cash, it's different. You just go ahead and put it right into the trust. You vest it right into the trust.
Right, but I mean, if the monies are in the trust, then how can I take out a personal mortgage? I can't really do that.
If the monies are in the trust, no, you can take out a personal mortgage. You can act on behalf of the trust as the trustee on an outside transaction. So you would have to qualify personally for the loan. Now they would ask you where the money's coming from, and you would say, I'm also the trustee of the trust that the money's going to be coming from for the down payment. But if you're not going to take out, if you're going to be paying cash, you don't have those worries. I just think it's going to be different if you're trying to do a mortgage.
So bottom line is that it may be individual depending on the bank and how they work.
I think that's right.
But
Yep.
You're saying you think it's possible to mortgage a property with trust proceeds in my name? Is that what we're saying, or no, we're not saying that?
We're saying that no, in the trust. I mean, if a bank will loan to a trust and they'll do it, go for it.
Okay, all right.
I think. I mean, right now I don't see a reason why not, but maybe there's some. I'll ask that question. That's interesting.
Yeah, if you could ask Richard that question,
Yeah.
I would appreciate a direct, firm answer on that.
Okay, I'll get it.
Thank you, sir. Havana on the web. Come on down.
Hey, Jerry. How are you today?
Good. How are you doing?
Good. Thanks for taking my call. I had a quick question for Richard. As far as if you have a trust and you are the head trustee and compliance overseer, the only way that I know of, like if you would want to take a salary as the trustee for getting income from the trust, as you being the trustee and compliance overseer, is that correct?
That the only.
In other words, the only way, like say if as the trustee you take a salary, a monthly salary, say.
Right.
Now, as far as your house and your cars and utilities associated, insurance, and all those things that are associated with trust-owned assets, the trusts would take care of that. But say like, if I guess my question is kind of if you wanted to purchase a private aircraft in the name of the trust, would you have to prove more or less that was going to be used for business of the trust if it's going to be your personal aircraft?
Well, you're talking about two different things. If the trust is going to buy it, it's not going to be your
well,
your
yeah, I understand
aircraft.
that. Yeah, I understand that. The trust would buy the aircraft, but the purchase for the trust as the trustee, I've heard from people that certain assets you can't purchase for the trust. I mean, the trust can't purchase them if you're going to use them, more or less for your personal use.
You're not though. You're not though. It's going to depend on what kind of business you're going to do. Okay. One of my dreams is I plan on buying an airplane. Okay.
Right. Mm-hmm.
The trust is going to buy an airplane. Okay.
Okay.
I have a friend that runs a charter service that I plan on putting it into the charter service. I plan on using it as a business.
Mm-hmm.
So when I'm not using it, when I don't have the need for it, it can be used for other things. So from that standpoint, I'm making an investment in a plane. the trustee is entering into an agreement to buy a plane using the trust funds. It will be used for trust business and beneficiaries business also. Beneficiaries are using it because you're basically doing it for the beneficiaries.
Mm-hmm.
So you have to haul your beneficiaries around with a plane. But yeah, you can do it either as an investment or as part of your business. You don't really have to prove to anybody what you're doing as long as you're now if you're taking $100,000 a week out of trust fund and you're using it to go to Vegas and you're going up there and gambling and doing a lot of stuff, I mean, maybe somebody's going to look at it, but no, if you're using it for trust business and the business of the beneficiaries or the pleasure of the beneficiaries, no one's going to question you. I can't think of an asset you can't buy through the trust.
Okay, and then my other quick question was
now let me give you one other thing too.
Okay.
So if as a trustee, the trust can buy an automobile, and the trust can let you drive it for the business of the trust.
Okay.
So, but if you use the money to buy you a Lamborghini, that wouldn't make sense. I don't know how that would be treated, but you just have to. But if you buy one car and use it only for the trust business, then that's not necessarily a taxable event to you because you have the right to do that.
Okay. And would that be the same as far as for like if you bought a personal residence?
Well,
with the
my
trust?
question is, are you married or not married?
Yes.
You're married.
Mm-hmm.
Okay, you're not buying the personal residence for you. You're buying it for the beneficiary.
Okay.
And because you have to sleep in the same bed with her or sleep in the same house, you have to live. You can now. If you were single and the trust bought a house, you could be the caretaker of it, but you would have to treat some small portion of that. You'd be buying that house for the beneficiaries with you as the caretaker.
Mm-hmm.
But you would have to declare some small portion of it as taxable income to you.
Now, if your children, adult children, actually would be living in the same house, would that still apply? Who were the beneficiaries?
Sure. Yeah.
So I mean,
you're buying the house. The house is being purchased for your beneficiary wife and or kids. That's what you're doing. You have to kind of think about. You're doing things for the beneficiaries. You're doing things for the beneficiaries. Right. Now, let's just say that you're a Harley guy, and you think that your wife is not a Harley girl, but yet you think that she needs a Harley. Then buy her a Harley.
Okay.
She doesn't get to drive it, but you put her on the back of it. You have to take care of it. So
I got you.
Just be cautious about things. Yep, thank you.
Appreciate it. Thanks.
Pensacola, Florida, 850. Come on down.
Hi, Jerry.
Howdy.
Thank you for doing the call. I really appreciate it. Richard, I have a question. I have one of your master trusts that I've done the deposit for. And if by some reason we don't RV by tax time next year, do we need to file taxes? And if so, can we use or hire your accountant there?
Yeah, you will be contacted by Richard Stinson just a little bit later with you probably will have to do a zero tax return, but it's a 1041.
Right.
But he will contact you depending on the situation. If we have an RV by October, November, he'll be in touch with you with a different message than if we go tomorrow night. So.
Okay, perfect.
I'm sorry, go ahead.
No, that's all I wanted to know is just, what would we do next? So I appreciate it.
He has everyone who is a client of ours, he has their information. and he will be in touch with all of you at some point.
Okay, thank you so much.
Yes, ma'am.
Thank you. Well, we're going to take one more caller here, and then we're going to call it a day. Paris, California. Come on down.
Hello, Jerry. How are you?
Just fine. How are you?
I'm well, thank you. Hi, Richard. Greetings to the room.
Hello.
Richard, I have a couple of questions for you. The first one, will there be any type of training for this specific trust? Not a charitable trust, not a business trust, for just maintaining this particular trust?
Yes, there will be. Yep.
Is that going to be post-RV or?
Yeah, I would think it is. We want to have an event in Dallas, and the reason Dallas is because, well, that's where Masters is. I mean, and it's easy to get to generally from most any place in the country with one flight. We want to do that. In lieu of that, we will have other conference calls after the fact. There'll be a number of them, and you will and the meetings that we do have will be audio taped, and you'll be able to listen to them. So there'll be plenty of information and plenty of people to talk to you about any questions you may have and to educate you. Yes.
Okay, and so we're saying that there is no reason why we need to have any type of trust that segregates our assets, that our assets are protected against liability. Let's say, for example, we get into a car accident. It's clearly our fault. They go and file a claim against the trust. There's some liability there. So what would happen in that instance?
Well, technically, one of the reasons that assets, the trust is with a rare exception of in California and Texas, it's child support. A judge can order in Texas and California, a judge can order the trust to pay child support. Either a trust, the way it's written, if it's set up for the right reasons, either it is, and it's written with the spendthrift provisions. When you have an asset in the trust doesn't own the asset. You don't own the asset. The asset is being held in trust, and that's the reason it complies, and it generally, you can't penetrate the trust to collect. See, before you go through this, there's nothing that's going to keep. So let's just take a few minutes here. You've got one of your sons or daughters is in a car accident driving a trust car. He is judged to be at fault, and that's the reason you want to have in your insurance. You want to have even if you have your assets in a trust, you want to have an insurance policy with a good a good liability policy on it. So he's taken to court. There's a judge. He loses a lawsuit. There's a judgment issued. The judgment is against your son or your daughter. A judge can't even hear a case where a trust is sued, especially if it's this trust. So they're going to have to bring the claim against your son or daughter or whoever's driving the car. They get a judgment. Well, the trust cannot be penetrated for the debts owed by any parties to the trust. So and this is what I was trying to tell you about I logically walked through this with a guy yesterday, and he says they're telling us we need to have a different asset into each trust. Well, those are considered to be alter egos, and basically they can be penetrated. And yeah, I guess you could only lose what's in that trust if you're sued, but you can lose it inside of that trust. Inside of this trust, it's about as bulletproof as you're going to get. Is it absolute? Well, mean, you just got to look at O.J. Simpson. He didn't have it in 10 different trusts, and his trust was not able to be penetrated. It doesn't matter the reason. It's just, can it be penetrated or not penetrated? And it wasn't.
Okay. And my last question,
and
the
by the way,
beneficiaries.
by the way, if you had 10 different trusts with 10 different assets, you got 10 different tax filings.
Right.
People don't realize that. You have to file 10
right.
different tax returns. How complicated does that get?
Right, right. The beneficiaries, if the trust is their only means of income, when they go out and apply for anything, how are they validating their income? Are they stating that they're beneficiaries of a trust, or part of a trust, or employees of a trust, or how is that worded?
Recently, my nephew rented, he's one of my beneficiaries, and he rented an apartment. And so he just basically, he had to prove his income, and he had some good income, but we wanted to have more. And basically, I wrote a letter that says he can receive up to some number in income from the trust each month. And they just added that on, and they checked out my relationship with the bank and just checked a few things out, and they let him have the apartment. So
okay.
you can just write a letter that so much could be paid on behalf. Now, I don't give him the money to pay his rent. I have a check written from the trust to the landlord, and it's paid directly to a third party. It's supposed to be paid.
Okay, so you don't have to indicate exactly what your position or what your title or holding is. You just mentioned that you can, the trust can provide a certain amount of income for that person as a beneficiary.
Absolutely.
Or okay,
yeah,
as a beneficiary.
As a beneficiary, yes, ma'am.
Okay,
yep.
That's it. Thank you so much.
Yes, ma'am.
Thank you. Okay.
Thanks, Jerry. Good call.
You're welcome. All right, everybody. Thank you very much for your participation. And the replay link will be up here in a little bit. So as they say, goodbye.
Thanks, guys. Good day.
The conference is now completed. Goodbye. Welcome to the